people, just realize other people can hear what you're saying. And then please ask your questions, as I said, in the chat box, and we will go through the questions at the end. Okay. I will be putting links to our YouTube channel and to the consumer satisfaction surveys for the Alabama Council on Developmental Disabilities, who has funded us. This is our 3rd year. And so they are funded federally, and so they need feedback to give to, to share with the federal government. And so I will put those links to those questions in the chat box. It's pretty short. Please take time to fill that out. And then I'll put them again at the end too. And they'll be in Spanish, English, and Korean. So you can answer the questions regardless of language. And we're also, this is part of our research, and one of the reasons we've been able to get a 3rd year of funding is because of all the good feedback from the people who have participated. Yeah, so I'm going to put that on in just a minute as soon as I'm done talking. And our thanks again to the Alabama Council on Developmental Disabilities. I'm Dr. Doris Hill, and I'm the director of the Regional Autism Network. And I'm one of the primary investigators on this grant. And I'm also faculty at Auburn University, so in special education. And I'm going to hand it off to Maria Gutierrez, who's the RAN Regional Autism Network Family Navigator. And then she's going to hand it off to Dr. Sisson so he can introduce himself, and then I'll pull up his slides. Maria, your turn. You're muted, Maria. I think she's frozen. Okay, I'm going to go ahead and hand it over to you, Dr. Sisson. If you would, I think we just lost her. If you would tell us a little bit about your background. I think it's on your first slide, but just kind of introduce yourself and we'll go from there.
Good morning, everyone, or whatever time zone you're in. I'm really happy to be here this morning to present on the basics of the Americans with Disabilities Act. Again, my name is Dr. Graham Sisson. I'm a person with a disability myself. I was injured in a 1982 car accident caused by a drunk driver. I'm paralyzed from the waist down, and I'm a full-time wheelchair user. And I'm also an attorney for the state of Alabama, a deputy attorney general. My only client is the state government, but also I serve as I'm a 1990 graduate of Vanderbilt Law School and a 2016 graduate of Auburn University, War Eagle, with a PhD in rehabilitation and leadership, and certainly have the opportunity to use that information I obtained from the PhD to help people with disabilities. And of course, I have a lot of different bosses. I'm appointed by the governor of the state of Alabama, Governor Kay Ivey, and I'm also work for the Alabama Department of Rehabilitation Services, where I serve as a deputy attorney general and deputy legal counsel. And I serve as executive director of the governor's office on disability, and as the state's Americans with Disabilities Act coordinator, where I'm in charge of facilitating but not enforcing ADA compliance by over 200 state agencies. So I provide a lot of ADA information. I've worked with the Americans with Disabilities Act for over 32 years, and the ADA will become 33 years old this month on July 26th. So that's basically my background. I'm again glad to be here today. And so we can go to the next slide.
Okay, sorry, I just put the links in the chat, so you should be able to see them.
Okay, and the next slide is my contact information. We have an ADA hotline that was created by the legislature back in 1998. We also I have 2 offices, one in Birmingham, Alabama, and that's the 205 area code. And then I have an office in Montgomery, 334 area code. And of course, my email is bram.sisson@good.alabama spelled out.gov. And we do monitor our email and phone. And if you would like to call me and ask further questions, feel free to do so. Next slide, please. And of course, as a Deputy Attorney General, I have to say this, that all information provided is non-binding. That basically means it's not evidence in a court of law, but I feel it's accurate. But again, ultimately, a court of law decides legal issues. And this is a Reader's Digest version of ADA requirements. And what that basically means, it's a shortened version. It's not everything that's out there, because it would take a lot more than an hour to give you a complete rundown of all requirements and provisions under the Americans with Disabilities Act. Next slide. Okay, and this is my personal experience. I've already told you. I was injured in 1982 in a motor vehicle collision caused by a drunk driver. I was a passenger in the back seat. It was a classic case of being in the wrong place at the wrong time, but I also had a closed head injury that put me in a coma for 8.5 weeks. So I had a head and spinal cord injury, and I attended college and law school using a wheelchair before the Americans with Disabilities Act. And I've suffered employment discrimination. So when I talk about discrimination and why it's necessary for the ADA to prohibit discrimination, I've had a law firm one time where the managing partner said to me that they didn't hire me because he thought I could live off the government and receive government benefits, which that wouldn't even have paid my law school loans. So, and I've experienced public perception of people with disabilities, and I've abbreviated throughout my slides. PWD stands for persons with disabilities. I'm going to give you one example. The $5 episode. I had started practicing law in downtown Birmingham, and it was before the age of email where you could file documents electronically now. Back then, you had to bring a court paper to the courthouse to get it filed to the clerk of the court. But I was waiting on a street corner waiting for the light to turn. I was wearing a suit just like I am today with a tie, and an individual came up to me and put a $5 bill in my pocket. And the question goes, first question people ask, well, what'd you do? I kept the $5, of course, you know, I'm not stupid, but back then you could actually buy lunch for $5. But the idea was I was on a street corner, I was in a wheelchair, therefore I must be begging. They didn't see the legal file on my lap. They didn't see that I was dressed in a nice suit and everything. They only saw the wheelchair. So public perception, you know, most discrimination occurs because of attitudinal barriers. In the Americans with Disabilities Act are minimum requirements. It's not everything that you should do to help people with disabilities, but it's a start. And it's hopefully try to make better to include people with disabilities more in American society. So the next slide, please. And of course, here's some of the barriers. A lot of barriers are physical, or we call it environmental, like parking. You know, we use the word accessible parking instead of handicap parking because accessible is more accurate. In parking, you know, I need additional space because using a wheelchair to get out of my vehicle. Restrooms, you know, it's not just a wider doorway for somebody in a chair to fit into a restroom, but it's also having the toilet itself, the commode at the correct height. In enough room in a stall for somebody to access it using a wheelchair or another assistive device. And then aisles, hallways being wide enough, and there's access aisles for parking. That's the part of the parking space that's crossed. That's the part that enables me to pull my wheelchair out of my car and get out and have enough space apart from other cars. And then I mentioned about attitudinal barriers. This is really, the ADA brings awareness, but attitudinal barriers go beyond what the ADA can eliminate. Societal work. A lot of people with disabilities are not valued or to have low expectations set for them. And of course, you can predict the future by having low expectations for somebody with a disability. If you have low expectations, they tend to not to accomplish that much. So discrimination, and we talk about discrimination, you hear a lot of things about discrimination. Some discrimination is on purpose. That's disparate treatment. You'll hear legal terms using that. But then there's a type of discrimination that is inadvertent, and that's what we call disparate impact. That's where you have a policy that is so wide and broad that unintentionally excludes people with disabilities. An example of that, having a policy that requires a driver's license for identification. A lot of folks with disabilities may not be able to get a driver's license because their disability prevents them from driving safely. So, and then I mentioned the hardware museum. I went up to Huntsville one time, and this was after the ADA passed, and they had a sign on the door that said no wheelchair users allowed. And I'm like, that is obvious discrimination, because they were worried that somebody with a disability was going to go in there and bust up the place and couldn't control their wheelchair. So, and I've also been called a fire hazard. I went to church in Birmingham one time at a Catholic church, and at midnight mass, right before Christmas, it's a special time of the year. And I went to a place where half the pews were missing, and I sat there. Somebody was pulling on my chair before the service started, and they said, "You're a fire hazard." And the person that's calling me a fire hazard was actually themselves using a cane. And I could get around faster in my wheelchair than they could using a cane for mobility. So, and I told the guy, "I'm not moving." He said, "Well," and guess what? I made it successfully through that service, and there was no fire, and I was not an obstacle. I don't instantly become frozen when somebody answers fire. And I told the guy, I said, "If somebody calls fire, people better get out of my way, or they're going to have tire tracks on them for my chair." I say that very facetiously, not seriously, but that was a pretty much. And we have a question that we'll read at the end, I see in the comments. So we'll make sure we get your question. But we're going to answer the questions at the end. I hope that's okay with folks. So the next slide, please. And again, I serve as the ADA coordinator, and really I facilitate compliance. I mentioned this before, and I do not enforce it, but I serve as a clearinghouse for ADA information for all public entities. I give people non-binding technical assistance, and I can provide technical assistance to anybody that's a member of the public on ADA requirements. I perform site reviews of buildings to make sure they meet the ADA requirements. I assist in the resolution of disputes. And again, a lot of times I can get stuff worked out without somebody having to go to file a lawsuit. I also issue informal non-binding opinions on ADA issues. This is not the same as an attorney general opinion. So if people said that, I issue attorney, these are non-binding, and I think they're very informative though. Provide other technical assistance, so on other ADA requirements. So every now and then I'm going to take a sip of Mountain Dew so I can maintain my activity level. Doris knows about this. So next slide, please. And go ahead and go through all these if you could just, and then, and of course, these are the different disability laws that I'm not going to discuss all of them today, but I wanted you to have an idea that these have been around a while. And of course, the Americans with Disabilities Act is the one we're going to talk about. It was passed July 26, 1990. I think it is the premier civil rights law for people with disabilities. Then you have the Rehabilitation Act of 1973, Section 504. This only applies to entities that receive federal funding or federal financial assistance. And the Individual Disabilities Education Act is different than the ADA. The ADA and the Rehabilitation Act are what we call equal opportunity laws. Pretty much, if people with disabilities, without disabilities get it, people with disabilities should get it too. And then Fair Housing Act, the ADA doesn't apply to permanent housing. It applies to temporary housing or transient lodging like hotels and motels. But the Fair Housing Act would apply to apartments with 4 or more units in each building, okay? And the Air Carriers Access Act of 1986 provides people with disabilities with assistance getting on and off airplanes. So the Air Carriers Access Act covers things that the ADA doesn't. So I'd wanted to give you a global picture of the general federal disability rights laws in the United States of America. Next slide. And these are the central principles of the Americans with Disabilities Act. Understand these and you'll understand the gist of law. One is mainstream. That's the idea of full inclusion of people with disabilities in all aspects of American society. And equal opportunity doesn't guarantee the exact same results for people with disabilities as people without disabilities. But equal opportunity, another term for that is leveling the playing field. It gives people with disabilities an equal opportunity to participate. When I started working, I could not get under my desk at work because my wheelchair was too low. So I said, okay, buy me a new desk. Well, equal opportunity didn't require the law firm to buy me a new desk. They took an old desk and they put law books under each of the legs. It raised it up. It didn't look good, but it was effective because I could get under the desk and I could use the desk. When I made more money for the law firm, they bought me a new desk. So, but equal opportunity, again, we talk about reasonable accommodation later on. The employer or the covered entity like the business or the state or local government gets to choose which one. And then access. A lot of people understand physical access. They understand wider doorways and inaccessible bathrooms, accessible parking, but access is also communications access. If you're deaf or hard of hearing or blind or have low vision, making sure documents and communications are in accessible formats. For example, people who are deaf will need to know American Sign Language or the sign language of the culture from which they come, and they'll need an interpreter to communicate. Then, of course, folks who are blind may need documents in Braille, or people who are low vision may need larger print, but also computers have improved accessibility for people who are blind because we now have screen readers that will read text to them. You have little portable screen readers that will read text on soup cans and other documents. So, but the ADA is a civil rights law, and it's too bad that we need a law to protect our civil rights, but it's patterned after the Civil Rights Act of 1964, which covered race and sex and national origin. The ADA covers disability. So next slide, please. And if you could do all these real quick, and these are the 5 parts or 5 titles of the ADA. And what the law requires, when we talk about mainstreaming, these are the major aspects of American society, particularly employment. Title I employment, I'm going to talk about that, but it doesn't guarantee anybody with a disability a job. It gives them an equal opportunity at a job. It only covers employers with 15 or more employees. And then public entities, these are state or local government. And what the ADA Title II does is help to make programs and services and activities of state and local governments, which are also cities and counties, to make those accessible. Then Title III, public accommodation, what we call private businesses. The law has 12 categories of these, and a lot of times we typically think of hotels and motels here, or restaurants or bars. These are examples of places of public accommodations that are covered as private businesses under Title III. And then, of course, telecommunications. This is what mandated the relay service. If you're deaf or you have a speech impairment, you have difficulty communicating over telephone, you could use what's called a text telephone or a telecommunication device for the deaf to communicate over the phone. And you type out a message That message goes on your TTY or TDD. That goes to a third-party operator that also has one of those. They call up the person that doesn't use one of those and relay the message back and forth between the person that's deaf or speech impaired to the person that's not. That took a long time. A 5-minute conversation could take 30 minutes. But now we have video relay, and that allows an interpreter with a video phone who can see on a screen the person who's deaf. They can communicate instantaneously, and it's no different than communicating with somebody who doesn't have a speech or a hearing impairment or who is deaf. So if I referred a deaf person one time to the relay system, they laughed at me. They said, Graham, join the 21st century. In other words, video relay. So, and you can call a number to access video relay. So in the miscellaneous provisions, these are the catch-all provision that apply to all the titles. But one of those is the prohibition against retaliation. If you advocate for your rights as a person with a disability under the ADA, you're protected from retaliation. Somebody cannot act against you because you tried to engage in a protected activity or protect your rights. Or this is another way the ADA applies not only to people with disabilities, but if you're a person who doesn't have a disability and you advocate for somebody that does and you retaliate against, you're protected under the Americans with Disabilities Act. Next slide, please. In associative discrimination, this is another way. Normally, the ADA applies to people with disabilities as defined by the ADA, but also applies to people that associate or have a relationship with people with disabilities. And if you'll click once more on this slide, here's examples: parents of children with disabilities, business partners of somebody with a disability, friends. And a business partner, I'll give you an example. If you had a business partner who had AIDS, somebody else figured out that they don't want to do business with you because your association with a person with AIDS, that's associative discrimination that's prohibited by the Americans with Disabilities Act. So again, it's another way that the footprint or the reach of the ADA or coverage of the ADA is expanded beyond people with disabilities in some circumstances. Next slide. And this is the basic rule under Title I, the employment provisions of the ADA. Again, the ADA does not guarantee somebody with a disability a job. What it does, it prohibits employers from discriminating against qualified individuals with disabilities. Those are individuals with disabilities who can perform the essential functions of the job with or without reasonable accommodation. And remember, the ADA Title I doesn't cover all people with disabilities. It can only cover those who can actually perform the essential functions of the job or major job tasks with or without reasonable accommodation. So you have to be qualified to be covered, to be protected by Title I. And that's because employers need to be able to hire qualified people. If you're not qualified, they do not have to hire you. And if there was two people and you were a person with a disability and somebody else without a disability had greater qualifications than you, the employer could still hire that person. Next bullet point on the slide. And again, this is just another way of describing a qualified individual with disability. It's also an individual who, with or without reasonable accommodation, can perform the essential functions of the employment position that such individual holds or desires. So it could include an applicant for a position where they need reasonable accommodations in filling out the applications, excuse me. Next slide, please. And again, it covers employers with 15 or more employees. This includes private employers like IBM, for example, or the Publix grocery store, but also includes state, local governments with who are employers, and employment agencies like temp agencies, temp agencies that find workers for a job, labor unions, Joint Labor Management Committee, but it doesn't cover the United States government, executive or judicial branch, but it does cover the legislative branch, Congress. This is one law that Congress did not exempt itself from. And of course, the U.S. government is not. Why is the U.S. government not covered? It's not covered because you have the Rehabilitation Act, Section 501, that covers the U.S. government as an employer. Next slide, please. Covered employees. And again, I put this special effect here to kind of make sure you're awake here, okay? Your eyes are not failing. Don't adjust the vertical or the horizontal, okay? That's a joke going for us old timers. Only us old timers will appreciate that. But to have a disability can perform the essential function of the job with or without accommodation, reasonable accommodation, can include former employees. They can't fire you and then say, well, you're not covered anymore because you're no longer employed. You're a past employee, you could still be covered by the Title I of the Americans with Disabilities Act. Next slide, please. And here's something that's important are pre-employment inquiries and medical exams. And if you could go ahead and do the rest of the bullets here. An employer is not allowed to ask any question likely to elicit information about a disability during the interview process. This means you can't ask any questions related to disability or likely to obtain information on a disability on the application or during the interview process before there's a conditional offer of employment. And disability-related inquiries also include asking employees' coworker, family member, or doctor about employees' disability. So let's say that a family member comes with somebody with a disability to an interview. They can't look at the family member and say, hey, tell us about their disability. That's illegal too. So next slide, please. Okay. And here's an example of things that can ask. What is your disability? Disability-related questions. Examples of those are, how did you become injured? Because some people like to know about you and say, hey, I noticed you use a wheelchair. What happened to you? That's illegal at that application or interview stage. What's wrong with you? And a lot of people, when they ask me that, they usually add an expletive, to that, which I won't mention, okay, because a flight company. How long have you been injured? Will you ever recover? Have you ever filed workers' comp? Because workers' compensation could indicate a condition that it could be a disability under the Americans with Disabilities Act. Have you ever filed? Why did you take sick leave? Do you take any prescription? They can ask you, how many days of sick leave did you take? That's a non-disability related question because anybody can take sick leave. They don't have to have a disability. How much did you use illegal drugs in the past? I don't know who's going to actually answer that question, but do you need reasonable accommodation to perform the job? This is one, you should always focus on the ability to do the job. Ask job-related questions, the ability to do the job. Those are acceptable. But do you need reasonable accommodation to perform the job is a legal question because only people who would answer yes to that are people with disabilities. But you can ask, you can rephrase that and say, can you perform the essential functions of the job with or without reasonable accommodation? That way you put the ability to do the job before disability. So next slide, please. Here's types of reasonable accommodation. This is not an exhaustive list. You can be creative, but make the facility accessible, like putting accessible parking or widening a door, modifying written examination training. You might give somebody an oral exam instead of a written exam where they're not able to use their hands or they don't have the technology. You could adopt flexible company policy. This is what we call reasonable modification policy. So if your company required a driver's license for ID, you could modify that policy to allow other forms of non-driver ID. Modifying the work site, moving things around, desks and chairs. So adjusting work schedules. You might allow somebody who takes medication early in the morning to make them sleepy to start later as long as they worked an 8-hour day. Acquiring and modifying equipment or devices, we have a special desk for somebody that will raise and lower, so that if they, depending on their height, with their disability, providing readers and interpreters. If you're blind, you could read documents to somebody. If you're deaf and need an American Sign Language interpreter, I'm not talking necessarily about a foreign language interpreter, because that may be required under a different law, the Civil Rights Act of 1964. And then restructuring job tasks, how a task is performed. It would be an example of an accommodation. But again, this is not an exhaustive list, but the employee should sit down and engage in an interactive process to determine what are the best accommodations. And then, but ultimately the employer gets to choose which accommodation to provide. Next slide, please. And the reassignment to a vacant position, it has to be a vacant, but now the law has actually narrowed that. The employer can still require you to compete for that position. So, next slide. Undue hardship is what limits the employer's duty to accommodate. If something causes an undue hardship, the employer is not required to provide that accommodation. They can consider other accommodations. And it's defined as any action causes significant difficulty or expense. It's not just money, how much it costs, but it also can be non-financial. I give the example of somebody that works at a restaurant. They have low vision. That restaurant turns the lights down at night to create an ambiance. It would be an undue hardship for that employer to destroy that ambiance by lowering the lights. So they would not be required to provide that as an accommodation. Next slide, please. Hostile work environment. Disability harassment is a form of discrimination under Title I of the ADA, much like, hostile work environment with other protected classes. Next slide. And again, who enforces it? I don't enforce it. The Equal Employment Opportunity Commission enforces the provisions of Title I. And you have to file a charge or a complaint with them within 180 days of any alleged discrimination. The EEOC will then issue a right to sue letter, and you have to use that before somebody can file a complaint in federal court. And you usually have 90 days from the right to sue letter to file a complaint in federal court. A right to sue letter doesn't mean that you have a case. It means that you can go to the next step, but you have to file a charge or complaint with the EEOC before you can go to federal court. Next slide. Title II of the ADA. This is the part that applies to state and local governments, as you recall. It prohibits discrimination in programs, services, activities, and facilities of public entities. And again, that's states, that are cities, and it may be counties. And it allows the provision of alternative methods. This is a change of practice to accommodate people with disabilities or relocation of service to an accessible area. When I was in college, I went to the University of North Alabama undergraduate. Most of the buildings were not accessible. They relocated my classes from inaccessible buildings to accessible ones. This was a form of program access under Title II. Next slide. And more information about program access requires that programs serve public entities are accessible to qualified people with disabilities. That's what QPWD when viewed in their entirety. Again, a lot of government services have eligibility criteria. But if you're already providing enough services, not every one of those has to be accessible. I'll give you an example. Let's say you provide transportation and you have enough buses with lifts on them to serve wheelchair users. You don't have to make every bus have a lift on it, because when viewed in its entirety, you have provided enough access. Often includes relocating program, as I mentioned, instead of making physical modification facility. But again, we have different types of facility. If it was one built for the ADA, then you could relocate. But if it's built after the ADA requirements, normally January 26, 1992, then you need to make that building accessible instead of relocating the service. An analogous standard for private schools under Title III would be alternative method service where modifications to an existing facility are not readily achievable. And again, I'm going to talk about readily achievable and what that is when we get to Title III. But again, the concept of Title II is program access. Next slide, enforcement. Can file a complaint in federal court or complaint with the Department of Justice. Again, the Department of Justice enforces Title II of the ADA. And they have a website, ada.gov, where you can file that, an online version. Next slide. Title III, public accommodations. And this discrimination, and it's by a commercial facility. That's basically an office building. And any person who owns, leases to, or operates a place of public accommodation and offers goods, services, programs, or activities to clients, customers, or visitors. It applies to visitors. And again, it applies to both landlords and tenants. They are equally covered by the provisions of Title III. Next slide. Who's covered? I mentioned private businesses. And a commercial facility is basically an office building. There's certain requirements they don't have to meet, but I'm probably not going to cover that today. I just wanted to make you aware of it. Next slide. Place of public comment. These were the 12 categories of businesses. The categories themselves are exhaustive, but not the examples. You have lodging, that'd be hotels and motels. Transportation, that would be like Greyhound bus services. Food service, we talk about restaurants. Display or collection, museums. Exhibition would be another example. A museum. Recreation, if you have let's say you have a private water park, or you have Six Flags over America in Atlanta, that would be an example of recreation. Public gathering, these could be gathering halls or music venues. Those are required. Education, I already mentioned about private schools like private colleges or even private elementary or high schools. Sales or rental establishments. I rent equipment from Home Depot. There's different services they have there that would be covered. Social services, homeless shelters that are operated by private entities would be covered by Title III. Exercise, Gold's Gym would be an example of an private exercise facility covered by Title III, the ADA, and of course other services. So the idea of this is to understand that there is a large number of different types of businesses that are covered by Title III. It practically covers all of them. There are exceptions. In the next slide, please. Who is not covered? Churches are not covered. They are exempt from Title III of the Americans with Disabilities Act because of separation of church and state in the United States Constitution. Private clubs that are truly exclusive are not covered by the ADA. Like the Mountain Brook Country Club in Mountain Brook, Alabama, would be an example of a private club. Apartments are not covered by the ADA because they're covered by the Fair Housing Act. Permanent housing is not covered by the ADA. Facilities. Next slide. Facilities, and this is just show you that there's no grandfathering under the ADA. Just because a building was built before the ADA was passed doesn't mean it's not covered. It's just at a different standard. Let's go back to that. I'm not done. New construction are the highest standard. New construction are buildings built after January 26, 1992. Existing buildings are built before January 26, 1992. You're required to make changes that are readily achievable. And readily achievable means easily accomplishable and without much difficulty or expense. Repainting a parking space is readily achievable. Adding an elevator or moving a wall is not readily achievable. And of course, historical buildings, you're not required to do anything that would just destroy an historically significant feature of a building. So next slide. and readily achievable, and I just gave you that definition. An example is a small ramp, like a ramp of a 3-inch rise, a 3 feet long ramp would be readily achievable. Restriping a parking lot to make the spaces bigger with access aisle, putting in an accessible parking sign. Doesn't usually include putting in an elevator, moving walls. Next point. And it's an individualized basis. That's the thing you got to remember. One size doesn't fit all. When you're accommodating people with disabilities, even people with the same disability have different needs. Next slide, please. Can file a complaint in federal court with the department, or a complaint with the Department of Justice. You don't have to go to the Department of Justice like Title II before you can file a complaint in federal court. You remember Title I, you have to go to the Equal Employment Opportunity Commission before you can go to federal court. Titles II and III, you don't have to go to a federal agency before you can go directly to federal court. Just wanted to make you aware of that. Next slide. This is telecommunication, and I mentioned about the relay system. It requires a relay system within each state, which offers access to individuals who are hearing impaired, deaf, or speech impaired. And Title V, miscellaneous. Yeah, sorry, go back, next slide. Yes, thank you. These are miscellaneous construction relations with other laws. The ADA is a federal law. Normally, federal law preempts or trumps local laws. But if a local law provides greater access than the Americans with Disabilities Act, that local or state law control. We have one such law in Alabama. In Alabama, trainers of service animals are protected under state law. Trainers of service animals are not protected under the ADA unless they have a disability, the trainer has a disability themselves. State immunity. States are not immune from the requirements of the ADA. And I already mentioned about the prohibition against retaliation. The ATBCB endorse, I know you know what that stands for, but I'm going to tell everybody else I'm teasing Doris. So it used to be called the Architectural Transportation Barriers Compliance Board. It's now called the Access Board. They create the standards for ADA accessibility, how wide doorways are, how wide parking spaces, other dimensions required for accessibility. And those standards for accessibility are called the 2010 Accessible Design Standards. They used to be known as the ADA Accessibility Guideline. And attorney fees are available to the prevailing party in a lawsuit. You have to file a lawsuit to get a prevailing party and get a court order saying that you won the case, or jury decision. You know, a lot of cases under the ADA never go to a jury. They're mostly bench trials. Unless there's intentional discrimination, I think sometimes you can get a jury trials when there's been intentional discrimination. So, and I gave you the Reader's Digest version of that. That doesn't cover all situations. ADR is alternative dispute resolution. This is what the ADA encourages: mediation and arbitration before you go to court. And of course, illegal users of drugs are not covered persons with disabilities. And other persons who are not covered are people with pedophilia or kleptomania, people who have psychoactive disorders caused by the illegal use of drugs. It used to be a commercial on TV. This is your brain. This is your brain on drugs, and it showed an egg frying in a frying pan. Well, if you fry your brain because you use illegal drugs, you cannot seek protection under the ADA, according to the provisions of Title V. Next slide. Here's the true and false, okay? And I'm trying to leave enough time so I can answer questions. So we're right on schedule. All people with disabilities are covered by Title I. That is false, because Title I, the employment provision of the ADA, only covers qualified individuals with disabilities. Next. Public entities must make all their buildings accessible. That is false. With existing buildings, they can relocate services from inaccessible existing buildings to accessible ones. Next slide, next point. Websites are covered by Title III. I didn't cover websites, but websites by Title II entities are covered. Websites, there's still some conflict whether or not they're covered in Title III. Some courts say it's got to be tied to a physical building to be covered by Title III. That is something that maybe the United States Supreme Court will have to work. But I would argue that websites are covered by Title III. Next point. Title I covers the federal government as employer. That's false because they're covered by Section 501 of the Rehabilitation Act of 1973. Next bullet. Undue hardship only covers financial concerns. That's false. I gave the example of the ambiance in the restaurant in turning on the lighting. Next bullet. Title III does not cover businesses with less than 15 employees. You remember Title I only covers employers of 15 more employees. Size does not matter as the coverage under Title III. Even if you have less than 50 employees, you can still be covered by the public access provisions of Title III. Next bullet. The ADA hotline number is 800-205-9986. Of course, that's true. I wouldn't steer you there. Okay. Next bullet. Title III covers insurance. And I didn't go over insurance, but insurance is covered by Title III. But insurers can still classify risk. If you're a greater risk, they can still charge you more. Okay. But they can't use your disability as a subterfuge to deny you coverage under insurance. I was denied coverage for life insurance one time. They're like, you're going to die in a couple months because you have a disability. Well, I'm still around 42 years later. And they quadrupled my rate. And then I got them. I said, look, I'm going to sue you guys. So I got them down to only double the rate. And then after 10 years, they gave me the regular rate. So abject discrimination. Next bullet. There's a complete listing of all disabilities covered by the ADA. That is false. Because we have new disabilities being discovered or classified every day. Next bullet. A person with a disability must ask for reasonable accommodation in order to get one. Yes, they don't have to use the word reasonable accommodation, but they have to say, look, I'm having trouble doing this. Can you provide this to help me do that? That's a basic way it would go. Next slide. An employee with a disability gets to choose the accommodation. That's false. The employer gets to decide, or the covered entity like the private business or the state or local government gets to choose, but it has to be effective. It has to enable them to equally participate. Next slide. And I have these scenarios in here. I don't have enough time, but I would challenge you to look at these scenarios and see if you can apply the stuff I've just mentioned to these. Like this first one is a Title III case. You know, it cover access under Title III. The next slide. This would be a Title II because this was owned by a local city or county. Next slide. And this one is again, this is a Title II case. This is actually based on Vulcan in downtown Birmingham. So next slide. Anyway, I'd like to just go ahead and go to the questions, but I just want, this is an employment scenario that you can try. This is more employment under Title I. Just go ahead and show the whole thing. And this is Title II program access, an example of that. All right, let's go to the next one. And this is an example of the Air Carriers Access Act. Next slide. This is an example of the Fair Housing Act. Scenario about the Fair Housing Act. Next slide. And this is an example of Title I, employment again, an issue about reasonable accommodation. Next slide. And then, of course, this is a Title II issue with sidewalk. Sidewalks are programs, services of the ADA, and they're covered by Title II. Next slide. And here's the questions parts. So, and usually I have a soundtrack where there's clapping in case y'all don't clap. So there you go. All right, let's get to the questions. Let me see it. Can I access the, let's see. Okay. Let's see if there's.
I forward you all the questions that were sent to me.
Okay.
Can you?
Yes. You forward them. Yes. I see them in here. Yes. Whoops. Let me go back to the chat here. Okay. Let me let's see. It says, thank you for presenting to us to learn about the ADA and other laws. However, sometimes parents of children with disabilities are afraid to report when discrimination has. And I understand that. That's why under Title V you have provisions against retaliation. They cannot be retaliated against, but I understand the fear. That's realistic. Let's see.
I just wanted to say that I put the ACDD survey back in the chat again, so please take the time to fill it out because we're very thankful to ACDD for funding this opportunity for training.
Thank you. Let's see. Here's one. It said, I would like to see more accessible restrooms for adults with disabilities who need assistance with toilet. And that's where we got those family assist restrooms. And that's one thing that's not required by the ADA. There's no standards in the ADA for that. But we're trying to work on that on a state level, and your state can too. More and more businesses are trying to put it in there. So let's see what else said. Let's see what it says. Where vans are accessible, the cost of insurance is, let's see, hold on a minute. For some reason it's not. Let me see if I can pull this up. Whoops. Sorry. Make sure I'm somehow missing. I'm going to start at the top. I missed this one. If I've missed your question, can you make sure can the law of the ADA protect the individuals with disabilities who are undocumented in Alabama? The answer is yes. It applies regardless of whether or not, as long as you're physically in this country and you have a disability, it would protect you against discrimination. On the Fair Housing Act, can the landlord, I'm sorry, I'm having trouble. Let's see. Can a landlord refuse to rent a unit to a family who has a child with a disability? Is this happen? Where should go for a complaint? There are different fair housing centers in Alabama that some are federally and privately funded. You can go to those fair housing centers. And if somebody can send me an email, I will send you information on the Fair Housing Center. But we have one in North Alabama, we have one in Central Alabama, one in South Alabama, and they will a lot of times help somebody file a complaint, and they'll try to help resolve disputes. And sometimes they'll even help somebody get an attorney who can help that person if it's necessary, if it can't get resolved at the lowest level prior to a lawsuit.
Would it be okay, Mr. Graham, if you share that information with me via email, so that way when I share the presentation, I could add that to all the attendees? Would that be okay?
Yeah, sure. Let me make a note. And these are just in Alabama, okay? All right. And okay, on the Fair Housing Act, see, on the Fair Housing Act law, can a landlord in Alabama refuse to rent to a family who has a child with a disability? That's happened again. I said they can't. I mean, there's familial status too under other parts of the Fair Housing Act too, but as far as disability, they can't. See. And this one, it said "Me gustaría que estar en español." I'm trying to learn Spanish. I'm taking a online Spanish course, but I can't read that. I'm sorry.
Sometimes I believe that if somebody connected later, they probably didn't hear that we have access. So, and sometimes people, their computer or their phone might not have the accessibility to be connected into that with the interpreter. So I apologize about that.
Oh, no problem. You don't have to apologize. Somebody asked the question. I think that we can get foreign language interpreter for the ADA hotline, but the ADA hotline is meant, it only covers Alabama. So only callers in Alabama can access the ADA hotline because it's a state service for people within Alabama. That's the way the legislation. So if they're calling from within Alabama, we can try to set up a phone call where I can get a foreign language interpreter. You know, I may have to call somebody back, but then I'll try to get that set up. Let's see, did I miss any questions?
Maria, we're having trouble hearing you.
There is one question about if a public school has an elevator and a student needs to have access, but the school is asking the student that he or she needs to come to the office for them to make it accessible. Is that a violation?
Well, I think sometimes they may have a key to that elevator to keep people from using it. I've had to do that, but I don't think that's necessarily a violation if the reason they're doing is to limit access to people make sure people without disabilities don't use it. So it depends on the situation, but if they were normally, if they put too many barriers for somebody to access an accessible feature, it could be discriminatory, but having them come to the office to get a key to operate the elevator would not necessarily be a violation, in my opinion.
There was another question about the presentation. So I just wanted to let all the attendees know that the presentation will be sent to everybody that registered, and it will be sent in English and Spanish. So you'll be having access to the presentation being translated into Spanish. And I don't see any other questions.
All right,
And
well,
I just wanted to remind everybody that the links are in the chat for the consumer satisfaction surveys for ACDD, as well as the YouTube channel. Go ahead, Dr. Sisson. I didn't mean to interrupt.
No, it's no problem. Well, it's been my pleasure to present to everybody. We did a quick overview of the ADA, and one thing I didn't cover as much detail was, who's covered as a person with a disability. It's a three-pronged definition. First is physical or mental impairment, that's substantial limits of major life activity. The second is record impairment. These are people that have a past history of a disability. And the third is regarded as having a disability. These are people that don't actually have disability, but they're treated as having one. And I can provide a lot more information about disability, but for purpose of this presentation, it's a very broad definition. It's going to cover both mental and physical disabilities. And most disabilities are going to be invisible. They're not visible like me. You can automatically tell that I have a disability because I use a wheelchair, but Many disabilities may not have any indication, but they're still substantially limiting somebody in a major life activity, which would be enough to get coverage under the Americans with Disabilities Act. And disability in itself can be a complex area under the law, but generally knowing those three prongs, those three parts, and if you meet any one of those, you could have a disability. And it's possible somebody can meet all three prongs too. So, and that's on a case by case, individualized basis. I mentioned the true false, that there's not a listing of all disabilities covered, because it depends. Endorsed members in my class, that was, it depends. You know, the ADA situations are individualized, they're case by case.
Mhm. Similar to special education. It depends.
Yes. But they borrowed it off the ADA. I'm just kidding.
I'll just do one more question on that.
Oh, do we miss another question on the chat? Did I get all the questions? What are reasonable accommodations for someone with a mental condition? And my answer to that is it depends. What mental condition are you talking about? Typically, it could be more time in doing an activity. It could be they could have a quiet room where they could go to be away from people. You know, it depends on what it is. It could be a break to take their medication.
Mhm.
You know, it depends on what the mental condition is and what they're trying to gain access to, whether it's employment or what would be the best way to disclose your disability. And I like to use Shakespeare. To disclose or not disclose, that is the question. And a lot of times it's a judgment call. And if you're applying for a job and your disability is not obvious, then, and it wouldn't interfere with your ability to do the job, you don't have to disclose it then. You would need to disclose it when you ask for reasonable accommodation and the need for the accommodation is not obvious. When I was applying for a job, they're like, well, you're going to have to drive. There's no way that somebody using a wheelchair can drive. So I didn't have to disclose that I had a wheelchair, but I brought them out to my car and showed them my car with hand controls. And I was able to show them how I could get in and out of the car and drive with hand controls. And they said, you're hired. That was their concern. So disclosing a disability, some disabilities have stigma associated with them, and that's unfair. But I would say many times that unless it interferes with your ability to do the job or you need a reasonable accommodation right away, it may be best not to disclose your disability until the need arises. Hopefully that answered the question. But it's a judgment call ultimately on whether or not the individual is comfortable when there's not a need to disclose it, such as reasonable accommodation.
I do not see any other questions, and I just wanted to say that this has been very educating for our families and our attendees, and I really appreciate your time.
Thank you, Maria, and I hate to do this to you, but there was my able executive assistant mentioned it. There was cost of insurance increase for accessible vans. That could be discriminatory unless they're basing it on sound actuarial data, unless they have objective evidence that there's greater risk for accessible vans. And I think that could be discriminatory, and that person may want to contact the United States Department of Justice by going to ada.gov. There's a possibility there. But the insurance company's got to have an objective reason for charging more for accessible vans. And, you know, it may be that the insurance could be because the equipment covered, you know, they have to pay more to replace the modified equipment on a van, which could be a legitimate reason for charging more. I would find out why they're charging more. What's the basis for them charging more for the van, for accessible vans? Thank you. Sorry to get that in. I just want to make sure everybody was covered.
Thank you. Dr. Hill, I do not see any other questions. I just want to invite our attendees to please take a moment to fill out the surveys. Those help us a lot with so that we could comply with our grant. And we hope to see you soon next month. Mr. Graham, it's a pleasure always having you and seeing and thank you for what you do for the state. And the question from Mr. Grant, do you want to say anything else?
I would just like to say it's been my pleasure to present. Thank you all for the opportunity. And I hope this information, I hope you found it useful. I appreciate it. Thank you all very much.
Thank you, Dr. Sisson. I just also wanted to say I learned a lot today and I forgot how funny you are.
Thank you.
And I wanted to say thank you to Ms. Baker and Ms. Mateo they are our Spanish language interpreters. We so appreciate you. You are of the finest caliber with providing this service to our families. And I wanted to thank ACDD one final time. I'm done.
All right. Thank you, everybody.
Thank you, everybody. Enjoy your summer
Bye.
and see you next month.